Used to be they didn't put them up till they were deceased. Now they put them up when they're no longer on the bench, but the ones that are still on the bench aren't going to get anything. So it looks like we've got 9 panels left. But how many people on the bench? Got enough for each remaining
Each one
judge?
should be replaced.
9. So that will show them where you're here in town.
All rise. The District Court of Appeal of the State of Florida and before the Fourth District is now in session. Judge Margaret Warner presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Be seated.
If we looked a little tentative going out there, we actually don't really know how to, I don't know how to enter the courtroom. We're learning as we go. Which incidentally, I'm telling everybody this because I watched somebody get really surprised on it. On the podium, if you haven't been there, there's a button on the left side to me, the right side to you. If you put your hand on it, the thing goes up and down. So just remember that.
Free rides.
Which if you need to get it up, raise it, or if you need to push it down, you can do that.
Do you mean the entire podium goes up or down?
Yeah,
Yes,
yeah.
okay.
Yeah.
You said the thing.
And I have a button here, and that when we're tired of listening to you, we push it, and then you just disappear into the floor. No, I'm kidding. Okay. We're ready to proceed with St. Mary's versus Strachan. And have you all divided your time with respect? Are you doing the entire thing for the respondents? Okay. Fine. Then you can proceed.
Good afternoon. May it please the court, Donna Crosby and Andrew Reef on behalf of St. Mary's Medical Center.
Can I ask you to hone in for me, really right off the bat so I know why we're here, and that is for you to talk about the irreparable harm that exists here as well as the departure from the essential requirements of law. I mean, can you lay those out for me, those 2 prongs that are necessary?
Certainly, Your Honor. The irreparable harm that exists hinges on the longstanding principles that the statutes that we are relying on were initially enacted. The hospitals, in conducting their peer review, rely on the confidentiality that's required with the peer review so that the doctors and the healthcare providers who participate in this peer review process are not going to be subject to reprisal, to being hauled into court and deposed or sued in litigation in civil court based on something that they said, this physician did this wrong or this was done correctly.
Okay, but let's talk about this for a minute, because I thought that that's what you were, that this was an issue where there's a statute which expressly gives you a privilege not to testify. And that would be a departure from the essential requirements of law to order testimony then. But when I'm looking at the statutes, I'm now wondering how they apply to what the judge specifically ordered in this case. Because he said, as to the 93-page report, the plaintiffs are permitted to question Dr. Black only as to the portion or portions of the report regarding the care, treatment, and condition of the decedent. And then the CMS report, they're permitted to inquire those portions of the report which relate to both the creation and development of the pediatric cardiovascular surgery program. Now, the statutes, we've got 766-101, which is on medical review committees.
Yes.
and the other one is on the peer review process. But my question, but it has exceptions as to what can be inquired into. Can you please explain to me how what the judge ordered here is contrary to or prohibited in either one of these statutes? Because I'm confused. He was very specific that these were, at least at this point, the order that we're dealing with, these were the only two things that we were permitted to inquire.
Certainly, Your Honor, and I'm guessing that you are looking at subsection 5, which talks about the fact that no person who was in attendance shall be permitted or required to testify, but then it goes on with the however clause that they can testify as to their own personal knowledge.
Well,
is that what?
First, yes, but it says the investigation proceeding in records of a committee. And if you look at the definition of committee, I'm wondering what, I mean, maybe I need some understanding of what was done with these two reports. Because what seems to be in Section 5 that they're prohibiting, and the same thing with the peer review statute, is testifying about what happened at the proceeding itself.
Okay, and the word proceeding is kind of used in a broader term. This was what happened. There were two different reports. The one that we're referencing as the 93-page report was an independent physician reviewer who looked at the medical cases throughout the life of the program, a 2-year period of the program. That reviewer then...
That's the 93-page report.
That's a 93-page report, which we have, for purposes of production and these proceedings, have divided it into two parts. Well, it easily divides into two parts. One is the review of the program. One is a review of 8 specific medical cases, which we have conceded falls under the Amendment 7's definition of adverse medical incident. The review of the 8 cases, we have produced that. The review of the program in general, we produced in redacted form. The plaintiffs have moved to compel the unredacted form, and that was just heard in front of the judge yesterday. The ruling is pending.
Well, okay, no, wait a minute. This is to the 93-page report.
That's the 93-page report.
So for the half that you, okay, but the judge only permitted at this point, and the order only permits questioning as regard to the part that you admit is covered under Amendment 7 and what have you. In other
Correct.
words, regarding the care, treatment, and condition of the decedent.
Correct. Maybe this will clear up. What actually happened at Dr. Black's deposition was that plaintiff's counsel, in questioning him, had the report, gave it to the doctor, was referencing certain parts of the report, wanted to put the report into as an exhibit to the deposition, was questioning the doctor specifically as to the findings in the report. So it's our position that although one part of the
okay, but we're talking report, and this is talking about proceedings, well, of course, and one of it says is the records of the peer review panel are privileged, except that, of course, we know, based on Buster, the records aren't anymore. And a person who was in attendance at a meeting of such group or of its agents may not be permitted or required to testify in any civil proceeding as to evidence or other matters produced or presented during the proceedings of such group. But in attendance at a proceeding, is that what happened with this report?
there was not in this case, as far as I understand it, a proceeding. There was an independent reviewer, and there were people who contributed. In this day and age, what happens is that it's not necessarily a proceeding as we think of, a meeting where people get into the room and actually discuss. It may happen that way.
Then does this really apply? I mean,
Because the statute says investigations. So to the extent that even if you're engaging in a telephone conference or whatever, or you're engaging in an email discussion, it's all part of an investigation. So
that would be, perhaps, that says that it is shall not be subject to discovery, but it says, and a person who was in attendance at a meeting of such group or its agents may not be permitted or required to testify. So the testimony is what is, that has to be in front of a group, according to the statute.
If you take it that literally, but as Judge Connor has pointed out, oftentimes what happens is these occur with the investigations by email, they collaborate by email or they collaborate by phone, and that, in that sense, is the meeting of the committee. And the people who contribute to, who are interviewed by the individual committee members, those are the witnesses who contribute to that peer review process.
Well, was the report, did that ultimately result in a finding that concluded with respect to the peer review, or was that just?
Or was that, yes, it did. There was an ultimate conclusion. There was a peer-reviewed process of the 8 individual cases as well as the entire program as far as the care and treatment that was being provided to these children in the pediatric cardiac program.
And both reports, the 93-page report and the CMS report, both of them made statements about whether or not something was done improper.
Yes, Your Honor. Yes.
Right.
The CMS report, the 93-page report, the statute that we're traveling under is 395.0193 subsection 8, which we talked about. The CMS report, which was conducted by the Florida Department of Health Division of Children's Medical Services, we're traveling under 766.101 subsection 1A1K, a committee of the Department of Health, committee of the Department of Health.
So both reports are, arguably speaking, covered by one of the other statutes that in existence before Amendment 7,
yes, Your Honor,
which provided that you could not really depose any of the participants about what they did as part of the investigation.
Absolutely, and that's our position. And our position is also, even if, for example, with review to the with respect to the review of 8 cases section of the 93-page report, which I think kind of ties into Judge Warner's question, even though we concede that we are required to produce it pursuant to Amendment 7, we do not concede that the testimonial privilege no longer exists.
But you said that you're going under K, but that says a committee of the Department of Health, a county health department, Healthy Start Coalition, or certified rural health work, when reviewing quality of care or employees of these entities when reviewing mortality records. You mean you think that is an open quality of care of anything?
It would include peer review, wouldn't it?
Well, I don't know. I mean, committee of the Department of Health when reviewing quality of care. Does that mean of any other organization? Because it's not, or quality of care within the Department of Health?
You know, the problem that we're running into with now taking a really fine look at these statutes is that they never really were applied they were applied broadly up until Amendment 7. So up until Amendment 7, the documents that are at issue in this case, there was no question that they were considered peer-reviewed documents. Anything that a hospital, any report that resulted from a hospital's review, internal or external review of its program for the purpose of ensuring quality of care, was considered peer review.
I want to address the contention you have that the portion of the 93-page report that talks about the overall evaluation of the program. I think you would have to concede the Supreme Court has definitely interpreted Amendment 7 very broadly when it comes to records. And in Amendment 7, it specifically talks about records relating to an adverse medical incident. And you're contending if you're discussing the overall program, you're not really discussing anything relating to a medical adverse incident. I have a little struggle with that, though, because my assumption is that the assessment of the overall program would have been based on an analysis of the 8 incidents, and certainly in the context of contracts and arbitration clauses, we say that relating to is very broad, and if somehow or another the dispute somehow touches upon. So I'm struggling with the notion that Amendment 7 doesn't require the disclosure of the overall program analysis or the effectiveness of the overall program if the evaluation is built in part, if not entirely, but at least in part, on the 8 adverse incidents. Help me with that.
I would like to try to help you with that. I had this same discussion with Judge Blanc yesterday at the hearing on the motion to compel the unredacted 93-page report. My response to that is that although the reviewer who produced the 93-page report did consider in part some cases that resulted in an adverse medical incident, the reviewer also considered other cases that did not result in an adverse medical incident, and the 93-page report, which is difficult to argue because the court has not seen the unredacted version, but it does not address a specific incident involving a specific patient, as the West Florida Medical Center case versus C defined that adverse medical incident report.
But wouldn't that simply mean that perhaps a in-camera inspection by the court's necessary to decide whether or not there was enough discussion of the 8 adverse incidents to relate to the overall assessment, so therefore it should be disclosed?
We have, Judge Blanc in the trial court has taken it under advisement with an in-camera review, and then we had a continued hearing to discuss that yesterday, and his ruling on that is still pending.
Doesn't Edwards kind of, Edwards, is that the name of the most
Yeah.
recent case? Doesn't
Yes.
they address that? Because in there they talk about the adverse medical incidents, then they say, in addition to those required by statutes, healthcare facilities can participate in and seek out additional voluntary committees and programs that provide additional resources on how to improve the quality of care rendered to patients. These additional programs and reviews cannot logically be excluded from Amendment 7's application simply because they are in addition to base-level statutorily required risk management programs. Moreover, the result asserted by Bartow would provide a trapdoor through which hospitals could totally avoid their discovery obligations by outsourcing their adverse medical incident reporting to external voluntary risk management committees separate from those required by the statutory scheme. So doesn't that indicate that as far as the reporting privilege, the documents, that they're going to read this very broadly to allow that?
The issue in front of the Edwards court was an external review, which is what we have here. But importantly, the hospital in that case conceded that it was related to an adverse medical incident, that it specifically, the attorney in that case had sent out for review that specific medical case that was at issue in that case. So we do not agree that our review of the program in general is a review of a specific adverse medical incident relating to a specific patient.
Well, then if that's the case, if you don't agree, then why wouldn't that, where is the privilege against disclosing that if it's not a part of an investigation of a adverse incident? I mean, which statutes cover it?
It's an investigation of a peer review committee. The review of the program, and traditionally has been included in this definition. The licensed facilities peer review 395.0193. Anything that a hospital undertakes to improve the quality of care at its hospital. So we are traveling under these statutes that preceded Amendment 7 and the discussion.
Well, you want us to read these statutes broadly, even though you admit they don't kind of exactly comply, to say, look, we are entitled to these privileges, even though it talks about somebody coming in front of the committees. You want us to read those broadly?
Well, there certainly was a history of reading them broadly prior to Amendment 7.
Well, I'm contrasting that from the fact that they want us to read Amendment 7 narrowly.
Right.
Amendment 7 narrowly, the only thing that Amendment 7 changed in the discussion is whether these documents related to adverse medical incidents, not even peer review that's unrelated to adverse medical incidents, whether these documents must be produced. Up until this point, up until Amendment 7, they were not to be produced. The statutes, there was no testimony, there was no admissibility, and there was no production or discovery, as that term is used in litigation, of these documents. The only thing that happened with Amendment 7 is that now the documents relating to adverse medical incidents must be produced. And it's our position, I'm sorry, Your Honor.
No, go ahead, finish.
It's our position in this case, what brings us here is that the issue is whether Amendment 7 also abrogated the testimonial privilege. And in making the argument that it did, the plaintiffs have relied on broad sweeping language in the Buster decision. And indeed, they have to do that, because if they don't, their argument fails. If you look at the plain, unambiguous language of the constitutional amendment, it does not talk about testimony, does not talk about evidence. It talks about access to records. And in the Edwards case, the court did look at that provision in the context of access to any records as to whether it was an external or internal review. But when they looked at it, they said, that's plain and unambiguous, any records. And so I would submit to the court that if the word any in that context is unambiguous, then certainly the word records, as opposed to testimony or evidence, is equally as unambiguous, and the court needs to apply the plain language as it is written in this Constitution.
I'm still hung up on the very first prong here, which is the irreparable harm that St. Mary's has to establish before you can access the fourth and obtain a writ of certiorari. I mean, tell me, I know that, I think in your briefs you mentioned that deposition questioning of Dr. Black might compromise the integrity of the review process, but, and correct me if I'm wrong, but as it stands now, that would assume that once that deposition is taken, that it's going to be disseminated to the public. I mean, we know that the CMS report and the redacted 93-page report is already available to the public online. But in terms of the deposition testimony of Dr. Black, until the trial judge says, okay, I want it released to the public, or it's now open to the public, how has St. Mary's suffered irreparable harm?
Aside from the chilling effect, which is the broader that you've recognized, Judge Sicklin, this is the quintessential example of a type cat out of the bag type situation, where we are trying to protect this particular testimony. If the testimony is required to be given before the court rules, that's the irreparable harm. If Dr. Black if they are permitted to question Dr. Black specifically as to what did you tell this committee? Were you aware that the committee made these findings? Those are the types of things that we contend are not to be discussed. Now, the second part of the statute of that provision does have the however clause that says, on the other hand, the witness can talk about anything within their own personal knowledge. So there's a fine distinction between that, but the cat out of the bag is exactly what we would have here. If he is on the spot, required to testify as to what went into compiling this report.
Let me ask one other question, because we're way over your time. That's okay. Nobody's behind.
I do have two other questions.
We've got a couple. Okay. We've been talking about the 93-page report. Let's switch back and talk about the CMS report. Was that reviewing an adverse medical incident, or was it, because it says, which relate both to the creation and development of the pediatric cardiovascular surgery program at St. Mary's. Was that just general information?
It was.
And how has that come under either one of these statutes so that they would be privileged as to any testimony?
That is a second review of the entire pediatric cardiac program, which came about approximately a year and a half after the review that resulted in the 93-page report. It was a voluntary review of the program that the hospital participated in with Children's Medical Services and probably, I don't know, 6 or 7 physician reviewers.
Figure into either one of the statutory privileges?
Well, there was discussion by CMS or investigation by CMS as far as at least some of these 8 adverse medical incidents that were in the 93-page report. Isn't that the case?
This was this was how it was established and what its criteria were for the program itself, right?
Yes, it was a review of the program in general, and I would cite to the Variety Children's versus Mishler case, which goes way back, and I can't remember the exact date of that case, but that was a JCO report, a similar type of program review that was conducted voluntarily on the part of the hospital, and the court said that fell within this peer review protection.
So the CMS report did not specifically discuss any adverse medical incident then?
The CMS report may have discussed some in the broad definition of relating to.
Okay.
There may have been, but it still is a general review of the program.
I want to go back to the chilling effect argument that you made, because on page 8 of your reply brief, you say some or all of these privileged information, this privileged information may be included in the final reports and disclosure. The same will compromise the integrity of the review process. That's a rather conclusory statement. Explain to me more how allowing deposition testimony is going to create this chilling effect.
In any case, the hospital conducts its peer reviews and depends on and relies upon the honest contributions of the healthcare providers. When you have, say, a surgery and you have the nurses and the physicians that were there in the surgery, or if you have an outside reviewer coming in, this outside reviewer, he practices in the community. He needs to know that when he is reviewing a particular medical case or the review of the program, he needs to know that when he's making recommendations, those recommendations are not going to come back to him in the form of a libel, slander action, that he's not going to...
But these are all but if he puts them in a report and it's in writing, then Amendment 7 lets the patients get to those. So why I mean, they're going to come out anyway.
Well, not necessarily everything that was told to the peer review committee ends up in the report.
So there could be oral statements that could come out in a deposition that you're concerned about.
Exactly.
Is there an issue as far as being able to find willing participants for the peer review in the sense of now I'm going to be subpoenaed and dragged into depositions, even though, you know, I wasn't the provider for services for this particular plaintiff, I'm now going to be dragged into lawsuits and depositions and all that
There very well could be, and in fact, in this particular case, it's a specialized area, pediatric cardiac. The particular reviewer in this case, the hospital had to go outside to find a reviewer to be able to have the knowledge to review this program. So yes, I mean, when there is such a specialized area, there is certainly that concern, Judge Connor.
I'm just...
Judge Warner, could I approach another issue?
But you asked before, let me ask.
Yes, ma'am.
You cited to me on the, what was covered by the statute, the Variety case, and I'm trying to find that in, I think you said it was Variety. I'm trying to find what case you're talking about in your petition or response, and I can't find one with that name on it.
Your Honor, it's at 670 Southern 2nd, 184.
What's the name of it?
Variety Children's Hospital versus Mishler. It's a 1996 case out of the 3rd District, actually.
670 Southern 2nd what?
184.
184, thank you.
This, at issue in that case, the circuit court had ordered the hospital to produce surveys of Joint Commission on Accreditation of Healthcare Organizations.
Can I approach another
Yeah,
subject?
go ahead.
In May of 2009, the 5th District issued the opinion in Florida Eye Institute versus Gamache, and they first talked about something the 3rd District identified in the criminal case, the difference between what's called fact work product an opinion work product. We subsequently, in the Fain case, made reference to that same difference, but in the Fain case, we didn't actually have to address the issue. But in the 5th District case, they said, we do not read Amendment 7 as evincing an intent from the voters to eliminate the privilege of opinion work product. So I'm curious, in your briefs, you didn't talk at all about this, the fact that there's, arguably speaking, a appellate court decision by this court, by the district court, saying that Amendment 7 does away with fact work product, but Amendment 7 does not do away with opinion work product. And I'm curious, is there a particular reason why you didn't touch upon that case law?
Because we traveled under the peer review privilege, we did not raise the argument that this was opinion work product in the sense that it was prepared in anticipation of litigation.
Well, let me ask, in terms of depositions, are you concerned about fact testimony, or are you concerned about opinion testimony? If we were to construe Amendment 7 as allowing the depositions of those participants in a peer review process, are you concerned about opinion testimony that may come out?
I think that is contemplated. I would definitely be concerned about that. I think that is
So
contemplated.
I don't understand why you would not have raised that issue in your briefs, because it seems to me that that would have been an argument in your favor, but I'm concerned maybe I'm missing something and there's a reason you didn't do that.
As I said, it was not, we traveled under the peer review protections, and it was not something that we saw as being related to attorney-client or work product in the sense that I believe that was discussed in Fain.
Well, the appellees, I don't think, really talked about it either. So, okay, thank you.
Okay, thank you.
Respondents, I should say.
Good afternoon. May it please the court, Kara Rockenbach on behalf of the respondent. If a tree or a document falls in the forest, but you can't ask questions about the document, does the document even exist?
Actually, I'd like to play off of something you said on page 10. Amendment 7 mandated that the adverse medical report CAT be released from the statutory bag,
Correct.
Given patients access to information. And that was a marvelous string of words, but I'm curious, isn't there a difference between the physical report being a different CAT from the CAT of mental impressions about the import of the report? Why should you be allowed in a deposition to go for mental impressions or whatever? Isn't that a different CAT?
Well, if we could just, it's not a different CAT, and this is why, Your Honor. Amendment 7 was broad. It was overwhelmingly 81% of the voters, over 5 million voters. So this court has to ask the question or answer the question, did the voters intend, when they enacted Amendment 7, that we get the documents but we can do nothing with them? Is that what access meant? When you look at Merriam-Webster's definition of access, it has two parts. One is to obtain access or obtain readily, and the second definition is to use. So it's logical that we get to use these documents, otherwise they'd be worthless. And
What about the testimony with respect to that? Because Buster, the Constitution, the amendment, nobody talks about whether or not they can testify. And I'm quite frankly, I don't think that you can read Buster as ever talking about that. As a matter of fact, I think that they have those provisions where at the hearing, the oral argument hearing,
Yes.
that they specifically said, we're not talking about that.
I was just reading those transcript pages this morning, 21 and 44 to 45, and I think it's Justice Periente who says, is this the issue before us? And that was asked, but it wasn't framed in that case about whether they could be testified to. So you're correct.
But if
You're
we've
correct,
got
Your Honor.
a statute, and this is why I spent so much time with Mr. Crosby talking about, do these statutes cover this? Because if you've got a statute that expressly says you can't have this testimony, then does a constitutional provision that doesn't talk about it at all trump this express provision?
Okay.
But now, after I looked at the statutes and looked at what they were actually having, in this case, having what the subjects were that the testimony was allowed, that's when I had my question is, do these actually cover that?
And when you look at those two statutes, I think Your Honor recognized there are, in both of those statutes, the word however. So the statutes never had a complete blanket prohibition against testimony to begin with. And then our argument to this court would be that post Amendment 7, these statutes, which Judge Connor, you recognize, they predate Buster, or they predate Amendment 7 and obviously Buster, but these statutes are trumped by Amendment 7.
Here's my problem. Because the amendment speaks only in terms of records, okay? And let's think about records in terms of information, okay? And let's think about information in terms of data. And if you think of it in that term, in those terms, okay,
Yes.
Amendment 7 simply says that if there is something in writing, there is an audio recording, or there's a transcript, that is historical data,
Correct.
okay? You're entitled to that.
Absolutely.
That's completely different. I don't think I'm concerned whether, although I will concede, the appellees have very strong points, both in Buster and in the Edwards case that you gave a supplemental authority. There is some language in there which seems to say the Supreme Court might possibly include deposing. But what bothers me with that position is the fact that now you're talking about information, data, that's not in existence. It's not in existence until the deposition occurs. So I don't think the voters talking about records were necessarily thinking in terms of future information in the form of depositions.
But the voters were talking about providing access and therefore logically use of those records that are in existence. Like I said before, the provision or the providing of these documents is meaningless and worthless, and it eviscerates the purpose and intent of Amendment 7 if we can do nothing with
But
them.
you can do, because the whole point of discovery is discovery will lead you to other information that will
Absolutely.
become admissible evidence.
Right.
Not everything that you discover is going to come out during a trial.
Oh, I
okay?
agree.
So the
Absolutely.
point, you keep saying you can't use it, but you can, because there will be things said in those reports that you then realize, well, I can look over here and find something, I can look over there and find something. So you can still use it. And the other problem is the Supreme Court and the courts have said Amendment 7 is not just to deal with litigation issues. It's so that the consumer can get information to decide, do I want to go to this hospital, do I want to go to that provider?
Correct.
That all makes sense if you think in terms of historical data. It does not make sense that a consumer would be able to have some kind of access to information that's not in existence because the deposition hasn't occurred.
It could lead to, the access could lead to additional information. This court,
Kind of like the discovery of the reports can lead to something else as well.
Absolutely, and Amendment 7 was not limiting. Amber Edwards, during the oral argument of that particular appeal, questions were asked about the limitations, and you had raised the fact and opinion work product issue, Judge Connor, that came up in that appeal. And my focus during oral argument, which you can see is picked up in Justice Lewis's opinion, is that it is expansively broad.
You're right.
But
he doesn't address whether or not there's still the issue of attorney-client privilege and there's still the issue of opinion.
which hasn't been raised by St. Mary's, as you
Understood.
noted. It may be an argument of waiver at this
Well,
point.
that was kind of disposed of in Edwards, though?
It was disposed of in Edwards in terms of the fact
work product. Exactly.
They did not answer the issue of attorney-client privilege, but that's not been raised, Your Honor. The issue that is, there are three issues. So the issue that's squarely before this court right now to rule on is whether my client can use these, admittedly at this point, adverse medical incidents, redacted, to depose Dr. Black. We have other deponents and other witnesses we'd like to use these reports with, but the trial order from Judge Blanc is limited to use with Dr. Black. That's number one. Number two,
and you contend that you should be allowed to go into all the medical incidents, right?
It is broad, and
Right.
based on Edwards, yes. Any and all, and yes, absolutely, we get it.
And the program evaluation as well.
Absolutely. I think Your Honor made the compelling point that but for these 8 adverse medical incidents, there would be no review of the program. I mean, you don't just do a review of the program without patients underlying that review. So, yes, it's part and parcel of the adverse medical incident and the broad interpretation of Amendment 7. But the second issue, the issue that this court is ripe to rule on is how we get to use them. Did Judge Blanc correctly rule, which we contend he absolutely did, that we are allowed to use these in discovery? We are not at the point of 90.401 and trial admissibility. So
But you're still talking about information that's not in existence. You're talking about using records to obtain something that's not in existence because you haven't taken the deposition. You don't know what that information is going to be.
We have no idea well, we have some idea because we have redacted portions of the 93-page report, and we do have the CMS report, but we are entitled to ask questions. In fact, I heard some of the statements by Ms. Cresby, and I'm leaning in to understand what that report actually was all about. I think you asked, Judge Warner, you asked the question, what's the background of these reports? I'm learning here today because I haven't been able to ask questions about them. So it is logical, it is common sense that when Amendment 7 was enacted, it was broad, and the voters overwhelmingly said the purpose of it, which is what this court must interpret, because the Florida Supreme Court says that the Constitution is the most sacrosanct of all expressions of the people. And so the importance of ascertaining and abiding the intent of the framers is emphasized so that you make it possible for the will of the people not to be frustrated or denied. If we are not allowed to ask questions about these Amendment 7 documents, adverse medical incidents, this court is or would be frustrating and denying the will of the people. The purpose of Amendment 7, which Buster very clearly quotes, the purpose statement of the amendment, and it says the purpose is to create a constitutional right for a patient or a potential patient. So you've got the past or current patient, and you've got the future patient, which, Your Honor, Judge Connor, you mentioned.
Future patient, but not future information.
But patient. And you can about adverse medical incidents, including medical malpractice and other acts which have caused in the past or have the potential to cause in the future. So this is the purpose that's outlined in the amendment. That's what this court is bound by in order to not frustrate or deny the will of the people. If we're able to obtain, and the word is access, if you look up accessible, which is, the word accessible is used both in the Amber Edwards decision as well as the Buster decision. If you look up the word accessible, it does not mean just that first definition of capable of being reached. It's also capable of being used. Now, we have to trust our trial judges. We have to trust that once these depositions are taken, then the very capable Honorable Peter Blanc, or hopefully Judge Blanc in September when the trial is set, will be able to look at what is admissible and what can come into evidence. But at this stage, to limit our discovery, that is not what the intent of Amendment 7 was whatsoever.
We have, let's see, it's been 10 years since Amendment 7 was
Right.
passed. And these statutes are still on the books. The legislature hasn't sought to repeal them.
There's been no need based upon Amendment 7. So, and Buster said, we're leaving intact what does not constitutionally be invalid based on Amendment 7. But if you look, there's no statute that says, and you won't find it, that now that we have Amendment 7, we can't use the documents in discovery or trial. There are references to discoverability and admissibility.
Well, then, when they talk in Buster about
Yes.
what provisions of 382, or 381, I guess it was, 381 or 380, whatever.
Are invalid?
381, or they're invalid.
Yes.
When they come, they said 234, and then they said, furthermore, we observe that in addition to the in addition to the limitation contained in subsection 6, the statute also provides that, quote, "All existing laws concerning the discoverability or admissibility and evidence of records of an adverse medical incident to any judicial administration proceeding remain in full force and effect." And then they say, because these restrictions and those identified by the district court conflict with the provisions, these statutory restrictions cannot stand. But they don't go on and quote the other part of it that talks about that you can't have testimony about it.
Right. No, they don't, Your Honor. You're absolutely correct. But that wasn't before the court in Buster, as Justice Pariente noted during oral argument. It is squarely before.
So in terms of a departure from the essential requirements of law here, the statute says you can't get this testimony. And you're agreeing that both of these statutes cover this, that the products are subject to these statutes. The two reports come within the purview, that even though there's no proceeding, as we would think of a trial or something like that, you're comfortable with them saying that they apply?
I'm actually not, because of the fact that Amendment 7 trumps the statutes.
Your position basically is Amendment 7 pretty much gutted all of those statutes, right?
It absolutely
Right.
does, based upon the broadness of the amendment,
Right.
based upon the intent of the voters, which is the purpose of the amendment, and the purpose would not be just to obtain these reports so that you can decide.
So you really want us to declare 766, 108, 1015, and 395, whatever number it is, 193.8, unconstitutional under Amendment 7?
To the extent that they conflict with Amendment 7, yes. Part of those two statutes or subsections that you just quoted have a however. And so we know that we are allowed to depose these individuals, not just Dr. Black, we can depose anybody, about adverse medical incidents, and not ask them questions about their testimony before the peer review board.
But you haven't asked the trial court to declare those statutes unconstitutional.
I'm sorry?
You haven't asked the trial court to declare those unconstitutional.
Did we ask the trial court? No, we did not. We
What?
did not. We actually did not need to. We needed to focus on Amendment 7 and the fact that.
But we really don't want to go that far and say it's all unconstitutional.
Well,
Not the entire.
Let me ask this with respect to what the judge actually said here. As to the 93-page report, the plaintiffs are permitted to question Dr. Black only as to the use, as to the portion or portions of the report regarding the care and treatment and condition of the decedent.
Right.
Is that information, does that come within the however clause so that they would be authorized to say it? Information, documents, or records otherwise available from original sources are not to be construed as immune from discovery, and any person who testifies before such group or who is member of the group may not be prevented from testifying as to matters within his or her knowledge. Wouldn't that be what Dr. Black would be testifying to?
It could. It could be. And I don't know if Dr. Black also testified before one of the review boards. And the first part of that statute then needs to be addressed or invalidated based upon Amendment 7.
And the same thing would apply to the CMS report, assuming that that's covered by this. The plaintiffs are permitted to inquire as to Dr. Black as to those portions of the report which relate to both the creation and development of the pediatric cardiovascular surgery program. If I'm not mistaken, wasn't it Dr. Black that developed that program?
Correct.
So he would be a kind of an original source for that, wouldn't he?
You would think, yes. That would make sense,
So
that he would have the original source.
But it's still part of
Question
the
of,
proceeding.
we know, I mean, without knowing what the questions are and how they're going to be asked, or even having the reports in front of us,
Right.
how do we know what is going to fall within what's permissible even under the statute and what's not?
Well, I have actually trial counsel, Mr. Searcy, who, if I have maybe 1 minute left, could tell the court what questions were asked of Dr. Black and stopped. I think
It's not in the record?
deposition was started back in 2015, if I'm not mistaken.
Is it in the record? In our record?
It's
in the
probably,
appendices.
to some degree, maybe argued in prior hearings.
I don't think it's
at the trial
appropriate to
court.
consider if it's
Okay.
not in the
Okay.
record.
Well, did you file an appendix with it in it? To show
With the deposition
questions?
testimony,
Yeah. Was that in your appendix? Didn't you file
I
an
don't remember
appendix?
seeing it, but it might
there
be.
is an appendix. I don't know if we filed the deposition of Dr. Black.
Right.
It got teed up based on a motion to compel and a motion for protective order from the competing sides. And the question was, are we allowed to ask anything about these reports? So to the extent that we ask questions of Dr. Black or anyone else, we have to hide the report. That doesn't make sense.
So because you think the two statutes are basically unconstitutional now after Amendment 7, I'm assuming your position is we should not be at all concerned about the fact that the peer review process, the integrity of that process is now going to be compromised because people who participate can be dragged into lawsuits and ask questions and all kinds of stuff.
I was thinking about that argument, and doesn't that apply to the actual generation of the document itself? It would apply as well.
Big difference between I participate in something and now something I've said got written up in a report, as opposed to now you're pulling me away from my practice and I have to go answer a bunch of questions and appear in front of a jury or whatever.
It keeps everyone honest in generating those reports if they have to explain them under oath. And if they...
But part of that honesty, though, it strikes me, you want third-party people that aren't close to it looking in. Isn't that really going to improve the medical quality? And isn't that why the federal government has developed this central repository so that all this information can come in, so that across the nation we can figure out, are there certain procedures being done that's actually turning out to be harmful? And you're going to need third-party participants to look at that picture to kind of give a independent analysis, as opposed to the locals who might think, oh my God, I got to be careful what I say here because now I might be exposing the fact that I committed malpractice or whatever. But you're going to lose those third-party participants if now all of a sudden they can participate and get sucked into depositions, at least, if not actual testimony in a courtroom.
There are certain requirements that the hospital and medical providers have to comply with. They have to participate in, by statute, by law, with some of the quality assurance and peer review. All that Amendment 7 said was we get those documents when they pertain to adverse medical.
But you're now saying that Amendment 7 allows us to take depositions of those people.
I absolutely am, because it just makes sense in that when we ask in discovery, when we propound a request to produce and we get documents, there's nothing in the rule of civil procedure that says you can request these documents and ask questions about them because
it's not a privilege out there that says that you're not allowed to depose these people.
But Amendment 7 said they don't have the privilege on these adverse medical incidents. That is not in existence now with the herald of a new era. Lifting the shroud of secrecy. And I would submit to the court that we have better medical care based upon the voters overwhelmingly enacting Amendment 7. And
I don't dispute that at all.
Yeah, there's no question that the production of these adverse medical incidents weeds out the bad, and it keeps the doctors more accountable, the physicians and the medical facilities more accountable for the care and treatment of their patients. To not be able to use these documents in discovery, not admissibility, this is solely discovery, would thwart the purpose of Amendment 7. It would thwart the purpose and the voters' intent, and it doesn't have to say the words "and use." The word accessible means to obtain and to use.
But if we agree with you and say it's discoverable, how is any court going to come back and draw the line and say, well, okay, it's discoverable, but now it's not admissible? So now all of a sudden it's admissible as well.
So the interesting thing about the admissibility argument, we're not there yet in the trial court, but it is independent of Amendment 7. The Florida Evidence Code would apply, and the trial judge is the gatekeeper of what is material and relevant under 90.401 or what would be unduly prejudicial under 403. So just because it's discoverable does not mean that it is automatically admissible. But there clearly was an intent for the vote, or intent by the voters to make this accessible, and not just for the document to fall in the forest and no one to know that it exists and no one to talk about it. It must be discussed and asked about, otherwise it's meaningless. It's just a piece of paper.
I agree with you. The record cat is definitely out of the bag with Amendment 7. I'm just not there yet on the mental impression aspect of it.
Well, we're not asking the mental impressions or opinions of an attorney. This is not a work product. These are documents that are created in a peer review setting, not an attorney making notes about what he or she believes or thinks in regard to the document. So there is a difference.
It's the difference between historical fact versus facts to be created in the future.
Facts that would be created in the future. I think the testimony would not be futuristic facts. The testimony from a deposition about the document would be, tell me about this document. Tell me what these words mean. What did you do? What
I'm
type
now
of...
giving you information that was not previously in existence, because now I'm telling you, this is my impression of what the import of those words in that report means.
But a physician's impressions about the report have never been privileged under some type of doctrine, or and in fact, Amendment 7 would remove, if there was some type of privilege within the statute, it would remove that. Because the documents, if their impressions are in the documents, they're gone. They're out of that bag. They're cat out of that bag. And I'm not sure if my trial counsel, co-counsel would like to add anything, because I think...
I would be glad to speak on any of the questions that perhaps we didn't quite know the factual answers to. For instance, questions that were asked about those documents at the depositions, but that's at the will of the court.
Well, again, if it's not on the record,
If we don't have them, I think we've...
The one issue I think that the court will ultimately have back in front of you is the redacted portion of 93, of the 93-page report. And that was argued before Judge Blanc and Judge Connor. It almost seemed like you were present with us in court yesterday, because you were asking the questions about relating to, which was exactly what Judge Blanc was asking both Ms. Crosby and myself about. So it might be that we will have an order from Judge Blanc and would submit this to the court, and perhaps the court would have supplemental briefing on the issue, so that we can have one opinion or one decision addressing not only the use of the adverse medical incident documents, but also the redacted portion being available to us, because it would be in the best interest, I think, of both parties in judicial economy to have all issues wrapped.
Let me ask you a question with respect to the deposition. Did Judge Blanc have a copy of that when he was making this ruling? In other words, if there is a portion of that that was there under 9200, we should never decide a case without the full record, and I don't know whether or not it was
I will
submitted.
look at the hearing transcript and see and work with Ms. Crosby. If it was before Judge Blanc, this court should have it, and I will supplement the record.
Okay.
I appreciate that question. Thank you.
Thank you. I've lost track of time, but I'll give you a few more minutes.
I have to, Your Honor. Just a brief rebuttal. First of all, with regard to the will of the people, the rules of statutory construction are very clear. You look to the plain language of the constitutional amendment. If that is clear and unambiguous, you don't need to go any further. But if you find that it is ambiguous, with regard to the will of the people, you look at what was in the ballot summary in front of the people when they voted. There's nothing in the ballot summary, there's nothing that was in front of the people that said, you can use this in litigation. This was a consumer advocacy tool, this amendment. It was never intended. The fact that it says patient has access can have access to the records, not plaintiff. The fact that it does not use discovery. Discovery in the litigation sense encompasses more than just production of documents. That we use the word discovery for requests for admissions, for interrogatories, the testimonial discovery. And what I wanted to point out, we don't need to resort to dictionaries to define what does have access to records mean.
Judge Blanc agreed with you, and he wrote in the order that, you know, your argument's very compelling, but for the language in Buster. And now, on top of that, we have to factor into the equation the language out of Edwards, where Justice Lewis said, we hold that Amendment 7 was aimed at eliminating all discovery restrictions on any records relating to any adverse medical incident. So the problem is the Supreme Court, arguably speaking, has included some language in its opinions which says that we have to interpret, or they are interpreting Amendment 7 very broadly to basically say that all discovery restrictions are off. That's one way you could read those opinions.
I may have to ultimately challenge the Supreme Court on that issue, which I don't look forward to doing necessarily, but The phrase "have access to any records" in the constitutional amendment says, making the records available for inspection and copying upon formal or informal request, and if they are publicly available, to notify the patient, not the plaintiff, not the litigant, where to access those documents. As far as making them available but not being able to use them, the argument that the plaintiff has put in front of the court, they are able to use them. They're able to use them, as Judge Connor pointed out, to make an informed decision as to what healthcare provider they are going to have perform their medical procedures. That is how the statute, the Constitution, had intended for these records to be used. They were never intended to be used in litigation. The only how we got so far afield was because the implementing legislation went in that direction. And in striking down those provisions that went afoul of Amendment 7, the Supreme Court in Buster simply invalidated the entire provision, the baby with the bathwater, even though testimonial and admissibility privileges were not in front of the Buster court. And they very clearly said, we are addressing only these issues.
Well, by invalidating 381, they also didn't invalidate 766 and 395.
Absolutely.
I mean, if they had wanted to invalidate both of those provisions, they would have probably done so. They were just looking at 381.
Absolutely, Your Honor. They took out 381 because, number one, they found that Amendment 7 was self-executing. They didn't really need the implementing legislation. So to the extent that it conflicted with Amendment 7, that's exactly what the Buster court did. When I argued this in the trial court with Judge Blanc, we painstakingly went through the Buster decision and identified every place in that decision where they talked about access to records. The entire focus was on access to records. There's nothing about testimony. There's nothing about discovery in other terms other than production of documents.
Okay.
Thank you.
Thank you. Thank you both. Very interesting issue. Court is adjourned.
Predates me, so